Honors.
And would you please call the first case for us?
Donna F. Howard versus James C. Howard.
Good afternoon, Your Honors. I am here today with Sophie Sabri for our office, who's assisted me in working up the presentation of this case. I also would give credit to Emily Stoltz, my office, who wrote and prepared both the brief and the reply brief, which I think both of them cover the points that we wish to make before you today. Let me just start off by saying,
Mr. Wagner.
I've been practicing since 1970.
Mr. Wagner, before you start, have you reserved any time for...
I'm sorry.
Have you
I reserved 5 minutes, Your Honor.
5 minutes, okay, good.
I've been practicing since 1970. And this case is the first case in my whole career where I get bounced out of court. I'm filing a motion and filing a response to a judge's request, and then all of a sudden there's no argument, there's no hearing, and the case is over. It's never happened to me before, and it simply makes no sense. The court said, as I noted on page 11, he said to the lawyers, why don't I talk to my law clerk? I want to make sure we have our ducks in a row, and both of you all probably a brief this about whether or not, setting aside the final decree, just one part of it, not the whole thing, but only one part. So he wanted us to do a brief on the issue of severability, whether you could segue a portion of a final decree out for consideration in Rule 60. So I filed my brief. I don't know whether the other side filed the brief, because I think it went to another court with another case number. This was on August the 1st. Then on September 11th, we get this decision which says, after argument of respective counsel and review of the record as a whole, this court finds the plaintiff's motion shall be denied. Now again, I believe in swift justice. This is a little too swift. It makes no procedural sense. It makes no substantive sense. The issues in this case are whether or not Rule 60 can apply in a situation like this, and we've briefed that in our argument, particularly Sections 1 and Section 5 of Rule 60. Even more so, we briefed the notion that the Court of Appeals has already said you can sever out parts of a judgment for the court's consideration. My client is not contesting the finality of the decree in this case. What my client is contesting is the attorney's fees. Now, the fact of the matter is that she had, in the marital dissolution agreement, she agreed to pay Mr. Daniel his attorney's fees. But she never received any documentation of those fees all the time of the representation. And we filed our case saying that his request for $105,000 had no basis whatsoever in terms of the work performed and the results obtained, and that we wanted the court to consider under Rule 60 to modify that attorney's fee dramatically downward from what she was to receive. And that was the gravamen of our case, that the attorney's fees were unconscionable, unethical, and frankly fraudulent in the fact that there was no documentation to support those fees. And that's what we had before the court. And that's what we wanted the court to consider. And the court said, well, first make sure that we can sever it. We wrote the decision, and in my brief, Ms. Stoltz's brief, clearly lays out the cases for this court that show that this is not a novel consideration. Then in the appellee's brief, they talk about Rule 60 and seem to suggest, based upon a case of City of Memphis versus Beale Street, that we could not do what we did. But the fact of the matter is that the court in that case said that we had the issue involving an attorney. Their argument was that Rule 60 can only be used with respect to the misconduct of an adverse party. The fact of the matter is that Section 1 and Section 5 of Rule 60 do not require an adverse party. And even more importantly, in the City of Memphis case, the court said, we recognize that under different circumstances, the conduct of a moving party's attorney may provide grounds for relief under Section 1 of Rule 60.02, and they cite the Terminix International versus Taylor, which says that the fraudulent conduct of moving party's attorney met criteria for excusable neglect. We also cited United States versus Krillage, where again, a motion to vacate was challenged based upon the attorney's lacking authority to enter into a settlement agreement. Again, it was a question of a mistake and inadvertence, and Rule 60 was appropriate. What we're asking this court to do, to get right to the chase, send this case back to the trial court, back to the new chancellor, and let the chancellor conduct a hearing to determine, number one, the issue of severability. Can you do it? I think the case is clear that you can. And then number two, to give us a hearing. Let us put on the evidence about this fee and the lack of support for it, and let the Chancery Court make a decision as to whether or not there was excusable neglect or mistake, so as to allow Ms. Howard to recover, so she's not going to be hit with this onerous $105,000 fee plus interest that she's had to endure as a result of the final order. Are there any questions of the court? If not, I will reserve my 5 minutes. Thank you.
Yes, sir.
Good afternoon. Please, court. I'm Richard Talley of the Jefferson County Bar, and represent Mr. Daniel in this case. I mean, first of all, it's a Rule 60 motion.
Mr. Talley, will you move the microphone to your...
Can you hear
There
me
you
better
go.
now?
Yes,
Very
thank
well.
you.
I'm sorry, I've been in this courtroom, and it's been a little while, and the acoustics are not the greatest, particularly with the people in the jury box, particularly not. But I mean, in this case, if there's a question about the reasonableness of the attorney fee that was incorporated into the judgment, signed off by the, of course, client represented, she signed the judgment, was in court under oath when it was signed by the chancellor, you would at least expect that there would be some proof in the record to support a Rule 60 motion that the fee is unreasonable. There's absolutely no evidence in the record supporting any argument that the fee is unreasonable. That's expert testimony. All it takes is an affidavit from a lawyer. To question that's not a reasonable fee. That's not in the record. So we think the chancellor made the right decision. Perhaps he didn't get to it on the proper avenue, but I think he got the right result. There's simply not enough in the record to set aside the judgment. That's what they're asking the court to do. And we think that the judgment should stand. Thank you very much.
Mr. Beckman.
Well, my response is this. I don't know what Mr. Talley, who's a dear friend of mine and worthy adversary, I don't know what he's talking about. First of all, in the motion we filed, it laid out paragraph after paragraph after paragraph about the unreasonableness, the unethical, fraudulent fees that were being charged by Mr. Daniel, number one. Number two, we never had a hearing, so how can there be a question of evidence? There's no hearing, so we were prepared to put on evidence. We were prepared to have a hearing on these fees, and the judge never allowed it. So I think Mr. Talley, in all due respects, is barking up the wrong tree. We ask this court to remand with direction. Thank you.
Mr. Beckner. What about the idea that these fees were agreed upon by all the parties in making the initial settlement for the divorce and all the actions that were related to that? What about that?
Your Honor, she signed the marital dissolution agreement, and in that marital dissolution agreement was the recognition of a fee to Mr. Daniel. She had never gotten, all the time that she asked for, records. What's the basis for my fee? How much do I owe you? And never got that information. She is a lay person. She signed the document, and when she came to see me, because she couldn't believe that she, in fact, was going to have to pay the $105,000. So we asked to see the documentation on this request, and never got it. Never got it until we had engaged in discovery and depositions and interrogatories. So she agreed to something that she did not have any information about, and that's where you come into the mistake issue. And yes, she's an educated woman. She teaches in the Knox County schools, but she's not a lawyer, and she's not involved in litigation. So she took a representation by her lawyer as to what the fee was going to be, and in fact, it was a gross fee. For instance, in a situation of this nature, in our verified motion, he charged her $5,000 to represent her in an order of protection hearing, which arose out of the fact that her husband shot her twice while she was in bed. The first bullet missed her. The second bullet got her in the shoulder. He never showed up for the order of protection hearing, yet he charged her $5,000 for that. And then all the guns were to be taken out of the house, and he charged her $5,000 to take the guns out of the house, okay? And by our documentation, the amount of time he spent in this case may have been 10 to 15 to 20 hours, at most. And we get a $105,000 fee. And Your Honor, simply stated, when you put the analysis to whatever information we got, this was a fraudulent fee, and she should not be held accountable to having signed that MDA with respect to this particular provision. Thank you.
Thank you, sir.
Thank you, Your Honor.
Thank you, Ron.
Well, your case now, I want to thank the lawyers both for your presentation. Your case has now been submitted for resolution.